Welcome and thank you for joining Seyfarth's webinar on the 2024 California Legislative Updates. All participants are in listen-only mode, but are encouraged to submit questions throughout the program through the Q&A section located on the right-hand side of your WebEx window. The presenters will do their best to get to everyone's questions. For those interested in CLE credit, an attendance verification code will be read during the presentation. We've recently introduced a streamlined process for accessing and submitting CLE forms. Towards the end of the presentation, you will notice a QR code on the left-hand slide and all the necessary information on the right. Simply scan the QR code with your smartphone and it will direct you to a digital attendance verification form. Once you've completed the form, you can submit it electronically. This saves time and ensures accurate processing of your CLE credit. Copies of the webinar recording and presentation materials, along with the CLE form, will be distributed to attendees in the days following the webinar. At this time, I'd like to turn the program over to Christina Lonnie to get us started.
Great, thank you. Welcome everybody to our 2024 California Employment Law Legislative Update. With me here today, after you see the legal disclaimer, this is informational only. It is not legal advice. You all have been here before. You know the drill. So we will pass by that and introduce you to our presenters today. Me, Kathy Feldman from our LA Century City office, and one of our amazing counselors, and Lila Wild up in our San Francisco office, who is going to talk to you about some of the PAGA specialization bills. To start off with, a review of our agenda today. So first of all, we will review the 2024 key dates from this legislative calendar year and what is to come to kick off the 2025-26 regular session. We'll then dive into the new laws, soon to be new laws. Everything will be effective January 1st, 2025, unless we say otherwise. So to start with, we will talk about some FEHA protected category changes. We will then talk about some time off and leave bills, some other workplace protections. Lila's going to talk about PAGA and a few industry specific bills, and then we will flag some bills that the governor vetoed and a few other notable failed bills, because what comes around goes around. You will see some of the bills we'll talk about today that are becoming law, have been seen before but didn't become law before, and we'll see some of the failed bills certainly come back in future years as well. So it's useful to keep them on our radar. So here again is the dates that I promised you all. We have stricken all of those other than the two that are up to come. First of all, as I mentioned, everything's effective January 1st, 2025, unless otherwise stated. And even in advance of that, the 2025-26 legislative session convenes December 2nd. They typically don't do a whole lot till the new year is happening. I mean, especially since they're in a special session right now, but we still do keep our eye on when they can start moving again for the new year and when new legislation might start going through the process. A couple of interesting data points, and as you can see at the bottom, credit for this is to Chris McKelly, a lobbyist here in town who really tracks all of these numbers and shares it with the Capitol community. So in the 2024 legislative year, 2,124 bills were introduced in the Assembly and Senate together. In comparison, last year, the state legislature introduced more than 2,600 bills, which was the most in a decade. So we're down from that number, but 2,000 is still a good number of bills. As of his signing deadline, September 30th of this year, the governor had taken action on 1,200 essentially of those bills. That was the highest number of bills to reach his desk during his tenure as governor. Of those that he took action on, he signed 1,017 and vetoed 189. We'll talk about, again, a couple of those vetoes and some veto messages he gave. And this veto rate is largely on par with the pattern that he has set in the past of about 15%. As you will see, as we dive into these bills, the new laws that employers are going to have to deal with come January 1st, 2025 are largely not as scary as some that we've seen in prior years, nor as numerous as some that we've seen in prior years. And what's the reason for that? The main reason, I think, is because this has not been the best budget year. And when you have bills that are trying to impose new requirements, there's a fiscal impact as well, and those weren't going to fare as well this year. We're also in an election year, so folks' focus is on different things in part. And last year was a very active year for employment laws, so we're in a bit of a down year this year. So keep all that in mind as we dive into the actual substantive bills, and you might be thinking, that's it? There still are some things you need to prepare for, as Kathy will kick us off with letting you know.
Thanks so much, Christina. So we're going to start off with a discussion of protected characteristics, which is already a pretty expansive list in California of the various qualities and characteristics for employees that are protected. But SB 1137 clarifies that under the FEHA, not only are individual protected characteristics protected from discrimination, but also the intersectionality or the combination of one or multiple of those characteristics. And this might seem, as Christina was saying, it's a little bit of a given. This is not one of those materially different type of bills like we've seen in the past. But the sponsors of the bill reported that there were some courts that resisted recognizing this possibility of intersectional discrimination claims. And so the bill was really intended to eliminate any of that lingering ambiguity and clarifying the protections afforded when there are multiple protected characteristics at play. California, as we're going to talk about today, tends to be the first to do a lot of things. And again, they are the first jurisdiction to explicitly adopt this concept. And as with other bills, the race discrimination one that we're going to talk about next being one of them, this impacts not just FEHA, but also the Unrwa Civil Rights Act. And with this one in particular, also the Education Code. So another one dealing with protected characteristics this year was AB 1815, dealing with race discrimination and the definition for that we already had under FEHA. As I'm sure most of you know, California in 2019 and several other states adopted the Crown Act, which included the definition for race for purposes of anti-discrimination provisions. And that definition referred to traits that were historically associated with race, including hair texture and protective hairstyles. What's happened now this year under this bill is an extension of that definition by removing the term historically. And the rationale behind that is that to determine whether a trait is historically as opposed to culturally associated with race can be ambiguous. And by the point, really the deeper and more impactful consideration is whether the trait is closely enough associated with race to serve as a proxy for racial discrimination. So, a small but maybe mightier change than the protected characteristic intersectionality change that we just discussed. Next slide, please. All right, so sticking with our discrimination theme, this next one, SB 1340, deals with local enforcement of discrimination. And it specifies that nothing within FEHA limits or restricts efforts by a city, county, or other state political subdivision to enforce local anti-discrimination laws. And there are some provisions within that as to when those local laws can be enforced, as you'll see here on the slide. Really, what does this bill get us? Proponents argued that while FEHA provides strong protections against discrimination, that the state itself lacks capacity and funding to really investigate and enforce the laws. And the thought behind this was that allowing local agencies to step into the shoes of the state agency essentially would allow for stronger and swifter enforcement of anti-discrimination laws. In reality, it's unclear how effective it will be in achieving those goals in other contexts where we have local agencies conducting investigations. We've seen that it can take several months, if not longer, for those local agencies to investigate and resolve those types of investigations. And that's typically due to understaffing, volume of claims, as well as their general familiarity with the topic and the subject matter that they're investigating. So it'll be interesting to see how much this really impacts what we see moving to local agencies, and whether it really achieves that goal of more efficient investigation. In addition, there is a new law regarding driver's license questions, really, in employment materials such as job advertisements, postings, or applications. Under SB 1100, employers are prohibited from including statements in those materials that an applicant must have a driver's license. There is an exception included there that if the employer reasonably expects the position's duties to require driving, and an alternate form of transportation wouldn't be comparable, then that type of question can still be included, or that type of requirement can be included in those employment materials. The type of alternate transportations that they're considering here are things such as taxis or carpooling, cycling, walking, type of ride-hailing services there, and recognizing that this is more impactful for some industries and clients than others, but it will be interesting to see how it develops and how impactful it becomes down the road. Next slide, please. All right, so this is our big leave-related bill for the year, AB 2499. And what this one did was it expanded and recasted a few different categories of leave, jury, court, and victim time off provisions, and made them unlawful practices under the FEHA. As you can see on the slide here, these categories of leave existed previously and they were addressed in the labor code, but by recasting them under FEHA, they're now subject to the CRD's enforcement authority. In addition to that move from labor code to FEHA, they've really also been expanded. So employers are prohibited from discriminating, retaliating, or terminating any employees who take time off under these leaves. As you can see here on the slide, time off for jury service with reasonable notice, time off to appear in court as a witness pursuant to a court order, or if an employee is a victim and takes time off to obtain relief for their or their child's health, safety, welfare, and the like with reasonable notice. And then for employers with 25 or more employees, if an employee is a victim or has a family member who is a victim, and they are taking time off for various reasons related to a qualifying act of violence. And I want to focus on that term, qualifying act of violence, for a minute. That is that's really the crux of the expansion here. It used to be a crime or abuse, and qualifying act of violence is really a broader category that can include domestic violence, sexual assault, and stalking, terms that I think we're very familiar with in California policies on these topics, but also an act, conduct, or pattern of conduct that includes causing an individual bodily harm, brandishing a weapon or a firearm, or if an individual is subject to a threat or a perceived threat of force that would cause physical injury. So that's definitely something to pay attention to in terms of that expansion. It also expands eligibility for reasonable accommodations to include employees who are victims or whose family members are victims of this type of qualifying act of violence. And reasonable accommodations, there's an enumerated list included within the law as to what that might entail, and it's relatively exhaustive. I won't detail all of them for you today, but if anyone is curious or thinks that they've got a current issue, please feel free to reach out. An important thing to note is that employers are able to request certification of the need for the reasonable accommodation, and that employees can also use their vacation, personal, paid sick leave time for this type of leave and accommodation, and that it would be running concurrently with SIFRA or FMLA leave, subject to the employee's eligibility. And this is a law where we've got a requirement that employees must be notified of their rights in writing. So that's something to pay attention to. Next slide, please. All right, another leave-related law is AB 2123, and this one is relatively simple on its face, that it removes the option for employers to require employees to use 2 weeks of accrued vacation time before they can access their paid family leave benefits. Um, it's a relatively small change. The goal behind it was that employees were considered to have been prevented previously from freely accessing the benefits that they pay for because of the requirement they use vacation first. And by deleting that provision, employers now give employees essentially a little bit more flexibility. Important to note that this one applies to disabilities commencing on or after January 1st, 2025. So if you've got someone who's currently already using paid family leave benefits or alerts you prior to that January 1st date, there's no obligation to make this change for those individuals. It's only moving forward in the new year. And this bill, one last note on it, is a reintroduction of a provision from a bill that was introduced in 2023. So to Christina's point previously, that what goes around comes around, we definitely tend to see some repeat players from the vetoed bills in prior years, and this is one of those. All right, switching gears a little bit. So this next bill that we're going to talk about, AB 2049, was signed into law on July 15th, 2023. So it's been in effect for a little bit already. And it impacts your litigation cases rather than your policies. So this one deals with summary judgment filing deadlines, and it was co-sponsored by judges, various judges organizations, as well as attorney organizations, with the goal of allowing judges to have a little bit more time with dispositive motions for their consideration. So you can see here, we've got a chart showing you the extensions. We've gone from 75 days before the hearing to 81 days before the hearing for filing of an MSJ or MSA. And we've gone to 20 days for filing an opposition and 11 days for filing a reply brief. In addition to the extensions of the filing deadlines, another important change under this law is that parties are now prohibited from filing more than one MSJ against one adverse party without seeking leave of the court. That doesn't impact motions for summary adjudication, and you can file multiple of those if appropriate without seeking leave. The law also prohibits the introduction of new facts in a reply brief. So a few critical changes there that will be impacting your litigation cases moving forward. And with that, I'm going to pass it back over to Christina.
Okay, so a couple more bills to close out what we have that is going to be new for January 1st, 2025. This one is the captive meetings ban bill, SB 399. This bill is one that was around last year as well and made it through and received the governor's signature this year. It enacts what will be called the California Worker Freedom from Employer Intimidation Act. I don't know that anyone's ever going to actually call it by that name because it's so long, nor can you get a good acronym out of it, but that's what it's officially called. And what it will do is it will prohibit an employer from subjecting or threatening to subject employees to discrimination or adverse action. And that's a confusing sentence, so my apologies for that. But essentially, to paraphrase, you can't discriminate or threaten to take adverse action against an employee who declines to attend an employer-sponsored meeting regarding the employer's opinion on religious or political matters, or if the employee affirmatively declines to participate in, receive, or listen to an employer-sponsored communication on religious political matters. Employers need to continue paying employees who refuse to attend such meetings. You can't say if you don't come, you don't get paid. And it imposes a $500 civil penalty per employee for each violation, in addition to other remedies. Now, it can be enforced either by the labor commissioner or by virtue of a private right of action, civil action, by a private party for injunctive relief. And, this is a law where we are expecting we will see some challenges, as opponents were very vocal that this is preempted by the NLRA. I mean, if you read some of the articles on it, it's very interesting in terms of seeing other states who or which have pursued similar legislation. We're apparently the 9th state to enact a law like this, including our vice presidential candidate, Tim Walz, in his state of Minnesota, enacted a similar law last year. In Connecticut and Minnesota, the laws have been challenged. And in Wisconsin, which was one of the first states to enact a similar law, the law was challenged, and the argument was that it conflicted with federal law, and essentially the state backed down from enforcing that law there. So we do expect to see some action as to the validity of the law here. Interestingly, it seems like while this is targeted at religious or political matters, that, it is a bill that was very important to labor. And at its heart, it's getting at employers talking to employees about unionizations, whether employees or whether workers should unionize. So this will be a really interesting one to watch and see how it plays out. But this was definitely a win for labor this year, since it's something that they've tried to get through the legislature before. The next two are different topics here. I think is the easiest way to put it, but they carry on a theme, right? So the first one, AB 1888, establishes the Labor Trafficking Unit in the Department of Justice. And this unit will receive labor trafficking reports from law enforcement agencies and other entities and refer the reports to the appropriate agencies for investigation, prosecution, or other remedies. And then AB 3234 is also getting at, somewhat social issues, but here, an employer that does its own social compliance audit will be required. So, this is an employer voluntarily conducting its own internal audit into its compliance with various laws and regulations that go toward, social issues within the company. If it does one of those audits, it's going to be required to post a clear and conspicuous link on its website to a report detailing the findings of its compliance with child labor laws. Now, this requirement applies whether the audit is conducted in whole or in part to determine if child labor is involved in the employer's operations or practices. As you can see in the second main bullet under this bill, the bill defines what social compliance audit means, and it is a voluntary, non-government inspection or assessment of an employer's operations or practices to evaluate whether the operations or practices comply with state and federal labor law. And it's essentially trying to get employers to self-report on the theory or premise that the state and federal enforcement agencies don't have the resources to do as much enforcement as they could or should be doing. Query whether it may result in there being fewer self-audits going on if you then need to report these sorts of things. But I think the bill seems to think that this would be a good thing that the employers could report on how they're doing with this sort of stuff. So we'll see how that plays out as well. AB 2299 is actually somewhat of a simple bill. It requires the labor commissioner to develop and requires an employer to post a model list of employees' rights and responsibilities under whistleblower laws. And it says that an employer can comply with the posting requirements by posting the model list that the labor commissioner develops. This bill amends section 1102.8 of the Labor Code and adds the one sentence new provision to as section 98.11 of the Labor Code. SB 988 is a little bit more involved, as you can see from the density of the slide here. But to simplify it for you, what the Freelance Worker Protection Action Act will do is require a hiring party, term of art there, to pay an independent contractor on the date specified by the contract, or if the contract doesn't specify the date for payment, no later than 30 days after the completion of the freelance workers, the independent contractors' services. It prohibits, as a condition of timely payment, requiring that the freelance worker accept less compensation than the amount that's specified in the contract, or provide more goods or services, or grant more IP rights than agreed to in the contract. I mean, that all seems rather intuitive, right? But it also requires an independent contractor contract be written, and that it contains specified information as set forth in the new law, and it requires the hiring party retain the independent contractor contract for no fewer than 4 years. So as we're flagging some of the things you need to prepare for the new year, one of these is making sure your document retention policies are updated to account for this new requirement if you use independent contractors. And then it also prohibits discrimination, adverse action as well against an independent contractor for asserting or attempting to assert rights under the provisions of this bill. It creates a private right of action with damages, fees, and costs available for a violation of these provisions. So with that, we're going to do a little bit of pass down memory lane for AB 2288 and SB 92 that were passed earlier in session, plus one new PAGA development.
Thank you, Christina. Hi, everybody. I'm Lila Wild, and I am here to talk about the PAGA reform. So there's been a lot of chatter about these changes lately. So if you read any of our blogs or anything else, you've probably heard something about it. But if not, I'm here to tell you all about it. So thankfully for many employers, on July 1st, Governor Newsom signed Assembly Bill 2288 and Senate Bill 92. And these changes offer relief from the oppressive effects of PAGA and effectively make the most substantive changes to PAGA in its 20-year history. So it's a pretty incredible change, just given there haven't been any changes whatsoever since it was enacted. So the reform law went into effect on June 19th, 2024. And the changes only apply to actions where both the LWDA notice and the civil complaint were filed after June 9th. So actions already pending where either the LWDA notice or the civil complaint were filed before June 19th are not going to fall under the pre-reform or not going to fall under the post-reform PAGA provisions. They will fall under pre-reform provisions, unfortunately. Before I dive into the changes, I just wanted to take a quick second to give an overview of what PAGA is for those who might not be lucky enough to have experienced it firsthand. So PAGA stands for the Private Attorney General's Act. It's a statutory scheme that empowers employees to act as private attorneys general to act on behalf of all, in quotes, aggrieved employees to enforce wage and hour laws. Aggrieved employees are employees who fall within a statutory period. They're generally, all non-exempt employees or something like that in California. PAGA has been really painful for employers because the cases can quickly become incredibly expensive. Even cases just involving a couple hundred employees during the statutory period can result in mid-six-figure mediated settlements with actual liability in the multi-millions. So it generally just really increases the cost of doing business in California, and it's already expensive to do business here. So why are these cases so expensive? Well, because there's massive civil penalties by default pre-reform. PAGA actions are not subject to class action type procedural boundaries. Arbitration agreements can't limit the representative claims. Broad discovery is permitted. And over the past decade, plaintiffs' counsel have just really run amok. There's been PAGA claims brought against employers, exploding numbers. Thousands are filed each year. It's insane, to be honest. So the purpose of the PAGA reform bills was to reduce the PAGA abuse by plaintiffs' counsel, protect businesses that do the right thing, also allocate a greater share of penalties to employees, which I'll get into in a second, clarify some ambiguous interpretations of parts of the statutes, and to focus PAGA exposure on actual experienced violations for employers who have not taken reasonable and appropriate compliance steps. So to go through, you can go to the next slide, please. To go through some of the facets of the reform bills. First, there's now a cap on penalties for employers who take reasonable steps for compliance. So the cap for compliance actions taken before an LWDA notice was filed, there's a 15% cap. And if employers take steps for compliance after receipt of the PAGA notice, that LWDA letter, there's a 30% cap. Wage statement penalties are capped at $25 where there's no harm. The California Supreme Court Estrada decision is codified, which explicitly provides that trial courts may limit the evidence to be presented at trial or otherwise limit the scope of any claim filed to ensure that the claim can be effectively tried. Also, one of the changes is a plaintiff must now personally experience the labor code violation they are seeking to pursue on a representative basis, and they must experience that labor code violation within the 1-year statute of limitations. There's no more derivative penalties, which is a big deal. Caps on penalties for isolated errors. There's also a change, this is something I mentioned earlier, just a couple minutes ago, a change in the distribution of PAGA penalties. It has always been 75% to the LWDA and 25% to affected employees. And now it's a 65%, 35% split. There are new and expanded cure provisions. There's an option to request a stay of litigation and an early neutral evaluation conference with the court. And the last thing is, excuse me, having penalties for employers who pay on a weekly basis. So there's no unfairness as compared to employers who pay on a bi-weekly basis. So these are the big significant changes. And there's also one, this is not the only PAGA, you can't go forward, sorry about that. This is not the only PAGA bill that Gavin Newsom signed. Just this last Saturday, there was one industry specific PAGA bill. So he signed AB 1034, which actually isn't a new law, it just extends an existing law. And it applies to certain unionized construction employers. I'm sorry, I'm losing my voice. And it basically says that employers in the construction industry, if employees are covered by a CBA, a collective bargaining agreement, that meets certain conditions, one of which is that employees are paid at least 30% more than the state minimum wage, then they are exempted from PAGA. And again, it's not a new law, it just extends a current law for another 10 years through 2038. And with that, Christina, I'm losing my voice. I will hand it back over to you. Sorry about that.
With that, we will rescue Lila in her voice and move on. Thank you, Lila, for the PAGA update. It is definitely become such a specialty, so we appreciate your expertise here. So the next industry-specific bill that was passed this year is AB 2738. And this bill is intended, the committee analyses are actually kind of an interesting read. It's intended to address worker fatalities and injuries occurring at concert festivals. You know, the sort of festivals where the workers come in, erect the stages and other structures, and you may end up having extreme weather or other conditions, or, you know, just a structure that's, you know, put up and taken down sort of thing that increases, according to the committee analyses, the risk of worker injuries. And so what this bill does is it requires entertainment events vendor contracts to state that the vendor will furnish to the contracting entity upon the hire of the vendor for a live event, information about the vendor's own and its subcontractors, employees, and the US and Cal OSHA trainings they have completed. So essentially, if you're entering into a contract with an entertainment events vendor, you need to make sure that you understand that their employees have been trained on federal and California OSHA rules and regulations and principles and other things that are required to be in that training. Separately, this bill also somewhat overlaps, but somewhat an independent concept here, authorizes public prosecutors to bring actions to enforce labor code violations to recover all remedies that are available under the labor code, not just a limited type of recovery. The remedies that are recovered are to go first to workers for unpaid wages, damages, or penalties, and the remainder to the state general fund. The bill also authorizes recovery of fees and costs to the prevailing plaintiff in any such action. The next industry-specific bills, which we're not going to spend much time on because they are so highly specific, but we still have them on the deck here and the slide here in case any of you do deal with any of these folks in your scope of work. The first to port drayage motor carriers, essentially extending joint and several liability in contracts there and for misclassification. And then AB 2364 changes the rate of pay that must be given in existing law for qualified organizations that provide mandatory sexual violence and harassment prevention training to janitors. You can see the increases in the rates that must be paid here on the slide. And then the bill also requires the Department of Industrial Relations to contract with the UCLA Labor Center to study opportunities to improve janitorial industry worker safety and rights. This is one of those topics that has been on the legislature's agenda for quite a number of years to ensure that janitorial workers are kept safe and free from harassment in their workplaces. So the moment you've all been waiting for those of you who are attorneys on the call, our CLE code. We have a new process. Not so new anymore, but new to those of you who might not have attended one of our webinars before. Get your phone handy, scan the QR code, and then when the form pops up, you will enter the information on the white square that looks like your iPhone or iWatch face to the right. And what you'll need to do is enter in the 2024 California Legislative Update, the date you viewed it today, unless you're looking at this later on in a recording. And most importantly, because those two details are easy to find, the third one not so much, the attendance verification code. It is SS as in Seyfarth Shaw 00 or 00, I guess to be more specific, 91. So that's SS 0091. Okay, I'll pause for one more second if you all had your phones put away so that you weren't multitasking or distracted during our enthralling presentation. So you can scan the QR code and then we will move on to the vetoed and failed bills. Checking the Q&A to make sure nobody needs extra time. Okay, moving on. Vetoed and failed bills. The reason why we are going to discuss vetoed and failed bills is because we've mentioned it many times today. You will likely see these again. I for some reason, love veto messages and signing messages. I always think they're super interesting because sometimes whoever writes them can hide messages in them, as happened quite often during the Schwarzenegger administration. Sometimes they're funny. Even if they're not funny, they sometimes provide a lot of insight into the governor's opinions on the topic. And these are two bills where that was the case. They weren't particularly funny and they didn't have a hidden message that I saw, but they do show that if these come back again next year, or at least the first one comes back again next year, it might have better luck. So the first one, SB 1022, would have changed FEHA tolling rules and extended the deadline for the Civil Rights Department director to file a group or class complaint to within 7 years from the date of the alleged violation. That's a huge, huge expansion. Now, Governor Newsom vetoed the bill, stating that it's just way too long. And he said, but I get what you're trying to do. I get that it's well-meaning. I get that the other things that this bill was seeking to do were also well-meaning. So he encouraged the legislature to try again next year with a more reasonable period for the CRD director to initiate a group or class complaint. AB 1832 continues a theme we talked about earlier in the slide deck with respect to human trafficking and that being a focus of the legislature this year, this one would have established within the Civil Rights Department the Labor Trafficking Task Force, which would be tasked with taking various actions and working with various state agencies to combat labor trafficking. In this one, Governor Newsom vetoed it because he said it's redundant of AB 1888, which was successful. There were a number of other trafficking bills that did pass this year as well, but that were not employment, well, that passed or went through the process that didn't make it through as well. So moving on from the vetoed bills, the other notable failed bills that are worth noting are benefits, and I'm almost purposely redundant here because some of these bills are redundant as well in terms of they were around last year and they're around again this year and didn't meet any better fate this year than they did last year. The first one, SB 1116, would have made employees after 2 weeks of an employee's absence due to a trade dispute or strike eligible for unemployment benefits under the Unemployment Insurance Code. If you remember, when we didn't have any new TV or movies for a while last year, that was because of the actors and writers strikes, and they all thought it sure would have made that a lot more bearable for them if they could have started getting unemployment. But ultimately back then and now as well, it did not make it through the process. AB 2494 would have required all employers, private or public, to provide employees with a written notice of coverage under COBRA, in person and via email, following termination or reduction in hours as specified. So if this one comes back, it's going to be important to note just because it would be another thing you need to add to your list to make sure that you are doing following termination or reduction in hours. But if you're thinking, do I need to do that now? Other than what you do currently, you don't need to worry about this new specific thing being a requirement by law. And then the final notable failed bill here is AB 2930 regarding automated decision systems. This would have regulated the use of automated decision tools in employment pay, promotion, hiring, termination, or task allocation for purposes of determining employment terms or conditions. In other words, this is one of the bills that was touching on the use of artificial intelligence in various aspects of society. For that particular instance, it was in employment, but it's also notable, and this is why we have this extra topic on AI here, that there was a lot of legislation on AI in California this year, other states as well. So we're expecting to see it come back and come back big next year as well. As you can see from the second bullet here, Governor Newsom issued a 4-page veto message on SB 1047, which was not an employment bill, but was purporting to regulate the use of AI or the AI industry. And so we definitely expect this to continue to be a hot topic, and follow our AI practice group here at Seyfarth because they do very frequently publish some really great thought leadership pieces on that topic. So with that, we actually have made it through the content early. So I don't know if Kathy or Lila, we got any questions that you wanted to address. If not, if you did submit a question or if you didn't have time to submit one but would like to, feel free to email any of us here, or if you submitted one that we haven't had a chance to take a look at, we can get back to you separately. Kathy or Lila, any closing thoughts?
I did want to add one note about another industry-specific bill that was signed in the middle of the session this year. It's one we've talked about before on other webinars as well, but on May 31st, so several months ago at this point already, I can't believe we're already in October. On May 31st, Governor Newsom passed SB 828, which delayed the implementation by 1 month of the healthcare minimum wage law that was signed last year. The impact of this in the immediate near term has already happened because the minimum wage increase would have taken place in July. It was only extended by 1 month. But the important thing to remember with this one is that that law also had wage schedules in place for subsequent years. And so it moves the date for those subsequent increases from June to July. So an important thing to keep in mind for all of our healthcare clients.
Very great point. Thank you, Kathy, for reminding us of that bill. I'm also putting up here just one last time because I see some folks were asking for a reminder of what the verification code was. If you missed it, here it is one more time. And I should note as well to Lila's section, if you all have a burning desire to dig deeper into PAGA, feel free to reach out to us or Lila, and we can point you to the more in-depth webinar on PAGA that Lila presented recently, as well as our PAGA blog that we have. And as you saw on the last slide, a lot of you I know have at least asked early on if we will be distributing a copy of the slides. We will, but we also have our CalPEX blog on which we posted our legislative update that has links as well to all of these bills, in addition to a summary of all the bills we've talked about today. So please feel free to check that out. Okay, if there's no other closing thoughts, I guess we will say thank you for joining us again, and we'll see you on the next webinar. One of the next ones we have coming up is a deep dive into leaves of absence, so please tune into that one.